Alex here with a perspectives video on competence, trial, and error, joined by defense attorney and candidate for Department 32 of the Eighth Judicial District Court, Christy Craig. Let's get straight into it. We are here with Christy Craig. Why don't you tell us a little bit about yourself and your campaign for Department 32 of the Eighth Judicial District Court?
Sure. I have been a lawyer for over 22 years. I have spent the vast majority of that at the Clark County Public Defender's Office representing indigent persons that have been charged with crimes. I am a trial lawyer. That means that I have trial experience, which means trials in front of a jury to verdict, which is a really important thing for a lawyer to be able to do. We all learn as lawyers how to read the law, how to apply the rules in the law to a particular set of circumstances. That's literally what law school is about. What you can't learn is trial skills. That's not something you can watch on YouTube and figure out how to do or read a book. You actually have to do it. And it's a skill that not a lot of people who are lawyers actually learn how to do. So district court, the court that I'm running for in Department 32, is a trial court. District court level is a trial court level, and therefore it's important to have judges who have actual trial experience in front of a jury all the way to verdict, and I have that. I've done capital and non-capital homicide cases. I don't even know how many felony trials I've done over the last 22 years, and as a criminal defense attorney, I'm in court at least 2 or 3 days a week. That's just part of the job. And right now there are 32 courts, 32 district courts in Clark County, Nevada. And of that 32, only 9 judges have trial and criminal experience in their history. And of those 9, we're losing 2 to retirement and to other things. And that's just not enough lawyers with that experience. It makes the bench weak on the criminal side. And that's a problem because when trials aren't done correctly, the Supreme Court makes you do them again. So having that experience is what I bring to the table, and I think it's important.
You touched on an issue that's actually going to make me skip to one of my later questions, but one of the things that we
Sure.
do is track error rates on the judiciary, and you mentioned specifically the context of criminal cases. Some people are genuinely curious as to why a defendant can appeal a judgment of conviction, but the state cannot appeal an acquittal, and to what extension does that underline the seriousness of the issue of a judge not having trial experience?
Well, I mean, constitutionally, the constitutions of both the United States and Nevada do not allow for a second trial after acquittal. So the DA, the prosecutor, does not have the ability to appeal an acquittal. But the Constitution does allow the defendant to appeal and to, make sure that all the work that was done by the state was done appropriately. It's important for a couple of different reasons to have trial judges, district court judges who have trial experience, because the decisions that they make during a trial are the things that are most likely appealed. That and jury instructions are the 2 things that are most likely what are appealed when someone is convicted. And if those things are done wrong, then it goes back to the district court to fix their error. Sometimes it's a new trial, sometimes it's a new hearing, but the point is that some of those mistakes are just simply because the judge doesn't have that bone deep, day in and day out experience, both in the criminal field and in trials.
Okay, so we've been monitoring several cases. On a couple of occasions, the defendant's competency to stand trial has come up. A very common question we are getting from the public has to do with what the difference is between what is generally referred to as the insanity defense and the issue of competency to stand trial.
Well, interesting that you brought that up because at the public defender's office, I had certain jobs over the years. I was a regular public defender, and then I was a team chief where I bossed around a group of lawyers and helped new lawyers become better, and then I moved to the murder team. But as a side job, a side gig, I did all the competency issues in our office. I helped establish Competency Court, which is a court within the Eighth Judicial District that assesses criminal defendants' competency. I also helped participate in the creation of Mental Health Court, and ultimately I sued the state of Nevada because they weren't transferring incompetent people for treatment to competency quickly enough. At the time, there was only one forensic mental hospital in all of Nevada. So every person in the entire state who was found incompetent went to one hospital, which was in Reno. They only had between 48 and 76-ish beds, and so there would be backups. So I sued the state of Nevada and I won. And as part of the consent decree, they built a forensic mental hospital here in Southern Nevada, the first one in 40, maybe almost 50 years. So competency is something that I've spent a lot of time on, and I'm very aware of how it works, and I've participated in it. So what happens is that the United States Supreme Court in 1960 gave us an opinion in a case called Dusky versus US, where they set the minimum standards for criminal competency, the standards that are set that a person has to meet in order for the state to be able to prosecute them, because it wouldn't be fair for the state to prosecute someone who couldn't participate, didn't understand what was going on, and was hearing voices. So they have to be able to aid and assist their lawyer, and they have to be able to understand the legal process. And I'm, compressing what the requirements are, but at its essence, that's what it is. And so when a lawyer or a judge or the prosecutor, we all have an independent duty under the statute, believes that someone may not be competent to stand trial, we all have a duty to raise that issue. Once it's raised, the person is sent to competency court, which I talked about earlier that I helped create. And competency court sends 2 doctors to see that particular person, and the doctors make assessments, and then they deliver reports to the court, which they tell the court what they found, whether or not they think the person is competent pursuant to Dusky. And then the judge accepts those reports. They either find them competent and they go back and they run through their regular criminal process, or they're found incompetent to stand trial, and the judge then transfers them into the custody of the state of Nevada for treatment to competency at one of those now 2 forensic hospitals. At that forensic hospital, they'll receive treatment, and sometimes that can go on for years. We've had very serious capital and non-capital homicide cases where the person has remained at the forensic mental hospital for 5, 6, sometimes 7 years. And they'll either make them competent and send them back for trial, or they'll find them to be incompetent without probability, and ultimately the charges are dismissed.
That's really detailed. Thank you. No, they actually love that. I don't know if you've seen our audience, but they get very technical. And in fact, you kind of led into my next question on mental health court. Our most popular case by far, we have 2 million watch time minutes at least at this point, has implicated a defendant's attempt to get into the mental health court program. And many of our viewers struggled with what it takes for a defendant to be admitted and what the difference is between mental health court and any other court.
So mental health court was created to be a diversionary court to treat and try to prevent recidivism by people who suffer from a mental illness. So the very first criteria is that they have to have a mental illness, but they can't be incompetent because they have to be able to make that decision about how they want to handle their criminal case. Do they want to enter mental health court? So a mentally ill person has to be competent but have a mental illness. So typically, a person will be found incompetent at competency court, go for treatment to competency at the forensic mental hospital, come back. Now they're mentally ill but competent because they're on their medication or the treatment has been successful. And then we determine whether or not they might be a candidate for mental health court. If mental health court determines they're appropriate and accepts them into mental health court, then the attorney who represents the defendant in the state will have to negotiate some kind of an agreement that resolves the criminal case, where mental health court is a condition, sometimes of probation, sometimes it's a true mental health court plea, which means if they successfully complete mental health court, the charges get dismissed. The actual outcome varies from case to case, charge to charge, defendant to defendant. The program typically lasts for about 3 years, and the goal is to get them on their medication, successfully working with parole and probation, housing, have them apply for whatever aid they're entitled to, and to kind of set them up so when mental health course is over, a mental health court program is over, that they're already on the pathway to success, and they've avoided some of the many things that can send someone, out of success. Like if they can't have continuous access to their medications, sometimes it's a problem. Housing can be a problem, and those things can be barriers to maintaining competency.
I noticed recently in one of our recently covered cases that a court-appointed attorney for the defense was questioned as to a certification to participate in the case because it involved the death penalty. I noticed, based on your background, that you were, I believe, certified under that rule. Could you elaborate a little bit more as to what that means and if there's any history behind why the rule was even created?
Sure. So the Nevada Supreme Court has a list of requirements for those people who will defend in a capital murder case. And it requires a level of competence and ability that's defined in what's called Rule 250. So there have been cases across the country over the years where people who were not competent to do capital cases participated defending someone when they should not have, because they lacked the experience, they lacked the ability, they hadn't done enough trials, they didn't know how it works. There's a very long, specific set of guidelines that guide the role that the attorney has to complete in order to be a competent capital defender. There are ABA guidelines, and then the Nevada Supreme Court has their own guidelines. So in order to be appointed to be chief defender on a capital case, an attorney has to be Rule 250 qualified. And I am Rule 250 qualified because I've done a number of capital homicide cases. So I meet that criteria. And if I was elected, out of those 32 judges that are currently on the Eighth Judicial District Court bench, I would be the only Rule 250 qualified attorney. And I think that that's an important voice to have, given that the Eighth Judicial District Court has set up what they're calling the murder team. So they have 4 judges who specifically hear those cases because they are complex, they are lengthy, and if you do them wrong, you have to do them over again. And that's a problem not only for the victims and the victims' families, but for the community, because capital and non-capital homicide cases are expensive, lengthy, and time-consuming. So everybody wants to do them right the first time around. So the Eighth Judicial District Court put together a group of qualified judges to handle those cases. The problem is that 2 of those very qualified judges are leaving the bench. And so we don't have anybody who is Rule 250 qualified currently on the bench. So I would be the only one in the event I was elected.
I recall some time ago, Justice James Hardesty, it wasn't a published opinion, but he mentioned in a footnote with a particular judge who was being consistently overturned on appeal, the frustration it causes not just the taxpayers, but the victims to have to do these cases over again. And I think at this point, I'd like to thank you so much for coming on. We really appreciated your answers.
Sure.